Hi, I'm Brian with Hanning Law Limited, attorney for businesses and creatives. Welcome to the second video in my series talking about the law of copyright. When I was talking about the definition of what copyright is, I discussed all of the different types of works that could be covered, from literary to architectural works and so many things in between. But there's a limit to that protection, specifically that for a work to be registrable, it has to fit within the statutory definition. And part of that statutory definition is that it is an original work of authorship. So we're going to talk about those two key words there, because work is your literary or architectural development. And authorship and originality are your other big test factors. And authorship mostly just means that you, or you and a group of other people, created the work. It is the active element. It is the intent to write the story, sing the song, and all of those pieces that take the idea and turn it into an expression, into a fixed work. For that intent and that expression, you are rewarded for the action under law. But like authorship, originality isn't really defined in the statute. We're really looking at how different courts have interpreted it through the different cases and controversies. Where authorship is relatively easy because someone has affirmatively stated that they created this work. Originality is a bit harder. We all live in the world and have sources and inspiration, and sometimes that level of originality doesn't feel that new and creative. What we're looking at is there are two main parts to the various tests that have been created, which is independent creation and a minimal degree of creativity. First, independent creation. Independent creation just means that you actually made the work. This is where we get a lot of these cases, is romance novels, where there are 1,000,004 books based upon similar ideas, be they a trope or a concept. Or independent creation is focused on the idea that the author was the author of the work. And this isn't a question about novelty. It is a question of creating a work without actively referencing somebody else's property. So it's the creation without copying. So it's not a question of, are you writing another vampire romance novel? It is, did you read a bunch of vampire romance novels, get inspired, and write your own take on the concept? How much came from your brain, and did you use the exact or close enough words that makes it seem like you just took somebody else's work? And this is primarily going to be an issue when you have a controversy between two works and two authors. A lot of what we look at now is things like if an author has a blog and the other person is reading that blog and is taking the ideas as they come up and looking to create the same or close enough kind of a thing. Independent creation tends to be presumed at registration. We're really going to be looking mostly at creativity in the registration process, which means that correspondingly, independent creation tends to be something that gets focused on in litigation if there's a conflict between works that are too similar. Which does bring us to the creativity element. As one judge said, the vast majority of works make the grade easily, as long as they possess some creative spark, no matter how crude, humble, or obvious it may be. Which means that the center of protection is the expression of the author. It is taking the tropes and conventions of the medium, but making your artwork, making your story, making your painting. Now, there are limits, of course. Brevity, for one. Currently, there are cases ongoing or being threatened about emotes in video games and dances being taken from pop culture in other medium. And whether or not there's enough creativity in a 5-second dance versus a 20-second or more dance. So we'll see some developments in that in the near future. We're also looking at taking protection away from, or protection just not vesting in, restatements of facts, as well as things like orders of menus in computer programs for the convenience of the user and not something that we want to necessarily provide protection in. Other things like the fact that you have to use onions, garlic, and tomatoes in making this particular spaghetti recipe can't be protected. Simple things such as notations of musical notes on a score, how that is commonly done, or the common patterns of how to stir and phrases such as bring to a simmer, things that everybody kind of needs to use in order to create their other work. In nonfiction, this tends to be your scène faire of things like the hero's journey, the very basics, the building blocks from which other artwork is then created. I went into a lot of examples. Really, the test is, have you done something that isn't based on a real-world fact or based on something that everybody has to use to create in your environment? If you've done something beyond those elements, then you have met originality most likely. So, broadly speaking, in creating your work, you are putting your expression into your creation for someone else to enjoy. As long as you're not copying from someone else or relying too much on foundational elements or fact, it will include enough creativity and originality for copyright law. If you would like to get in contact with me or to buy the book I wrote on copyright law, links are in the description below.